whether to reform criminal justice in India. I don't want to take too much of your time, so I just want to briefly introduce the two speakers we have today. As I said, one is Rebecca John. She's a senior advocate in Delhi, and she's well known for criminal law work and as well as the feminist law work. The other is Jawahar Raja, who's an advocate in Delhi. Again, he's well known for his work on UAPA trials and is now currently standing counsel of the government of Delhi. So first up, we'll have Jawahar Raja giving us a presentation on the committee process itself, why we must oppose the committee, and the dangers of what's being attempted. So Jawahar, over to you.
Hello. Am I audible?
Yes, you, Jawahar.
Yeah, thanks. Thanks so much, Mayur, for the introduction, and thank you, LiveLaw, for organizing this webinar. I feel like I have been speaking on this committee now ad nauseum on several sort of platforms, but I'm going to assume for today's program that we are also going to be joined by some people who have not heard about this committee, and therefore I thought I'll give people a brief background about what is the nature of the beast that we're dealing with. Sometime in May of this year, notice was put out by the National Law University Delhi that they have set up, like a committee has been set up by the Ministry of Home Affairs that is going to examine these three laws. The notice was up on the NLU Delhi website and was sent to certain lawyers, individual lawyers. And at that time, it seemed like the process was supposed to be only an expert consultation process. Many of us were concerned about what this process entailed, and therefore a series of representations went out from different groups, including civil society groups, retired judges and lawyers, and the women lawyers of the Delhi High Court, and then later on from other courts as well. The concern primarily at that time was about the fact that this process, which seemed to be ambitious by all counts, was being attempted right in the midst of a pandemic. By that time, we were already about 2 months into the pandemic. There had been 25,000 deaths. It would not be an exaggeration to say that the nation was in disarray. People were fleeing the cities for their homes, and some people were stuck in limbo. And there was extreme distress and distress migration. So initially, a letter went out from retired judges and senior lawyers asking this committee, look, it appears that you've been set up to examine these three laws. This is an ambitious exercise. Before you embark on this exercise, it's important that we have certain basic information. What are the terms of reference of this committee? Is there a concept note that this committee had come up with on the basis of which this committee has been set up and is functioning? Can you guarantee that your report and your process is going to be without not under the guidance of the Ministry of Home Affairs? You're not going to be reporting exactly what the Ministry of Home Affairs wants. And what is it that you're doing to ensure that there is greater diversity on this panel? Immediately as that sort of first expression of concern went, the committee put out a notice right on that day, saying that there are concerns have been raised about how representative we are, but we are in fact truly representative of a wide array of concerns from society. We are going to ensure that the process is as inclusive as possible. We're going to reach out to as many people as possible. And since a concern has been raised that this entire process is predicated only on being conducted in English and online, they said that we can even make efforts to ensure that it is not just in English, and that the proceedings are translated into other languages as well. Significantly, though, several of the other concerns that were raised were not addressed at all. The committee merely said that, look, the composition of the committee is not in our hands. It's the Ministry of Home Affairs that decides that. And therefore, we can't ensure greater diversity among our membership. And then the committee completely elided the question about what its terms of reference were, and completely avoided answering whether its report would first be submitted to the Ministry of Home Affairs and whether the Ministry of Home Affairs would have a veto on what went into the report or not. Also, one of the concerns raised was that, look, if you're going to, if this is a law reform exercise, then it has to be an exercise in public deliberation. Can you please guarantee us that the comments that are coming in to you, the suggestions that are coming in to you, are made publicly accessible and available, and that your draft report is also available in public for engagement and critique. On all these important issues, the committee was completely silent. Effectively, it ceded ground on one issue alone, and that was that whereas the initial expression of the project said that they would be putting out questionnaires that would require answers in 200 words, the committee said, no, we are not going to insist on 200 words. You can write in on longer responses. This clearly did not then address the concerns that were raised, and therefore a subsequent series of letters went out. Significantly from 16 retired judges of the High Court and Supreme Court and 100 lawyers. In this, the concerns raised were fleshed out in greater detail. Importantly, what was pointed out was that, look, the whole idea of a law reform exercise is to ensure that it is an exercise in public deliberation. This involves certain prerequisites. These prerequisites are recognized by all commissions that undertake such a process. Significantly, for example, the Law Commission on its website says that before we undertake a process of law reform, there is a protocol that we follow. Number one on the protocol is that we first do detailed background research on the topic. We come up with the facts that are relevant to what it is that we're examining. We identify the issues which are then discussed and thrashed out in the commission itself. And then we issue an issue paper or a think paper in which we put together all the research that has gone into what we have come up with. Right? So we identify what are the problems. We identify what are the other solutions that are available. We identify the state of the law in the country and outside. And this issue paper then accompanies a questionnaire, which is then put out for public circulation. And the Law Commission commits that it ensures that this questionnaire is widely circulated and that there is deep public engagement with this whole process. We know for a fact that while the early Law Commission reports had tended to adhere to some extent to the spirit of what set up the Law Commission. Significantly, for example, the very first Law Commission, which was constituted of 11 members, including M.C. Setalvad, who was the Attorney General of that time. It had 2 sitting High Court judges, 2 retired High Court judges. It had advocates general from 3 different states. It had advocates from many other states. The process involved them sending out this issue paper along with questionnaires to all the high courts and calling for responses from them. The Law Commission itself traveled to 14 high courts. Wide publicity was given to the fact that it was going to sit at those high courts. People were invited to come and even depose and testify in person. 473 witnesses testified to this committee. 6,000 questionnaires. This is 1956. 6,000 questionnaires were sent out to different individuals, bodies, and persons of interest, and they responded to this commission. And even after this deep process, the Law Commission, which was that report was meant to examine the status of judicial administration, said that, look, we have conducted this detailed process, and yet when it comes to reviewing the procedural laws, that is going to involve a lot more work than what we have been able to put together. Therefore, we are going to put this off for another day. And I say this because the entire process seems to have been founded on an assumption which seems apparent both from the statements of the Minister of Home Affairs, who actually set this whole process in motion, as well as from the chairperson of the committee, that these laws are a colonial legacy and that they have not been brought in conformity with the Constitution of India. So the foundation for this whole exercise is the assumption these are colonial laws and that they've not been examined since independence. Now, this foundation itself is fundamentally wrong, because right from the time of the setting up of the Constituent Assembly, there were demands that these 3 laws need to be rewritten because they were seen to be colonial. And therefore, the demand for the Law Commission was also propelled on the basis that these 3 laws and the CPC need to be rewritten. And the Law Commission, right from the first commission itself, proceeded with setting itself a target of rewriting all these 3 laws. And this process started, and it went through a rigorous and a long drawn-out process. The CRPC, for example, the process of rewriting it began in 1959 and went through 3 different Law Commissions and 4 different Law Commission reports until the final 37th Law Commission report resulted in the CRPC in 1973. Likewise, the IPC went through a detailed process of review and re-examination, as did the Indian Evidence Act. And each of these three statutes were, as we know, a product of a long history of drafting in itself. And there is a rich body of jurisprudence and literature that's built from interpretation by Indian courts, both pre-constitution as well as after the constitution came into force, to ensure that these laws do not violate the spirit of the constitution. So therefore, that fundamental idea that we need to change these laws because these are a colonial legacy seems to have completely ignored this history, ignored the fact that when the constitution makers were writing the constitution, they were cognizant of the fact that there were certain safeguards that were already there in the CRPC, and therefore they need not have be introduced into the constitution. So therefore, at this stage, if you're looking now to rewrite those fundamental principles which were taken for granted at the time the Constitution was written, and we are doing it without an awareness that all of this history exists, then that's a deeply dangerous process to begin from. Secondly, the Law Commission, as I already said, the 14th report of the Law Commission went through this detailed process. The Law Commission has set itself ambitious protocol for how law reform ought to happen. We know that some Law Commission reports are able to adhere to the stringency of that protocol, and some are not. Some are perhaps written with less rigor than the Law Commission aspires to on its own website. That being said, this process of law reform is not something which is being undertaken either for the first time in India, or it is something which is unique to India. Across the world, these law reform processes have been attempted, and there are protocols evolved in different parts of the world. The Commonwealth Secretariat has come up with a detailed study of how law commissions function and what are the best practices that law commissions can use. Now that of course uses examples of the UK and of Australia and so on, which perhaps are developed countries. Maybe there's an argument to be made that maybe it will be difficult for India to aspire to those standards, although that is not an acceptable argument when you consider the importance of these three laws, right? So then let's look at how the South African law reform process happens. The South African law reform process involves a detailed 7 or 8 step process that involves first a detailed examination of research into all the facts that are attendant upon the issue that is to be examined. All of that research, along with the comparative study of other jurisdictions and the study of the state of the law in South Africa, is then put into something that is called an issue paper. That issue paper is then sent across the country. Not only is it just merely sent as reports mailed to different places, but it is carried to different parts of the country where it is workshopped. That is, there are people who might not be able to appreciate or understand what the law means, and therefore it is important that people are made to engage with what the law might mean to them, and therefore it is workshopped, and people are given a sense of what the consequences of that law could be, what the consequences of that law and law reform could be for their lives. This issue paper, which is then workshopped, invites responses. Those responses come in. Then there's further research that is done on the basis of those responses, and they then go on to inform a discussion paper. That discussion paper is meant to bring up to date all the research that has happened so far, as well as a draft legislation and the other possible solutions that were considered, but for whatever reason have not made it into the draft. And this discussion paper then is once again put into the public domain so that people can apply their minds to the specific law that is sought to be implemented, and there can be an evaluation of why X solution is better than Y solution has been dropped out, and so on. And this discussion paper is then once again discussed at great length, and research is conducted. And after this long drawn-out process, the entire study is concluded with a draft law that then makes it into Parliament. Remember as well that the South African Law Commission makes a special effort to ensure that those who staff the South African Law Commission, they have I think 14 legal assistants, are drawn from a diverse array of social and socio-economic background to ensure that the law reform process is not held hostage to the concerns of the elite alone, right? So this is how law reform can be done. This is how law reform should be done. And I say this because it should not be understood that one is opposed to the idea of law reform. Does the IPC, the CRPC Evidence Act need reform? Yes, it does. Is Indian criminal law in a state of disrepair? Yes, it is. The question is, how is this process to be sorry, I've been asked to be a little louder. I'll try to speak up a little bit. The question is, how is this process to be carried out? How is this process to be carried out, and how are we going to ensure that it reflects, in fact, the problems that are faced from the laws by the people on the ground? And for that, we must ensure that the panel that is looking at the issue itself represents a diverse array of Indian society. And yet what we have on this panel is, despite repeated complaints that this is not a representative panel, we have 5 men from broadly a very small, narrow social band who are going to sit and are going to examine the suggestions and the critique and so on that comes. And that's a problem in itself. That apart, if you examine the process in which these 5 men have decided to go about it, and perhaps the fact that they represent a narrow social band has a telling effect on the way in which they intend to go about this process, is that it is going to be, it has been and it will be entirely internet-based and only in English. We've had lawyers from Tamil Nadu as well as Karnataka writing to this committee as well as to the Home Ministry in Kannada and in Tamil, informing the committee that we are trial court lawyers, we are not comfortable in English, we want you to translate all of your proceedings into Kannada and Tamil so that we can engage with this. Remember that in several parts of the country, trial court practices have subtle but important distinctions in how the trial plays itself out. And therefore, it's important that each separate state that is going to engage with how this overall national law is going to be implemented has a say in this. Therefore, it's important that the trial court lawyers, not all of whom are comfortable in English, are able to engage with this in their respective languages. And yet, this matters nothing at all to the committee. The committee has proceeded to stick with its deliberations only in English and to stick with deliberations only through an internet-based questionnaire protocol. It was pointed out to me the other day that the irony is that the advice and guidance to prosecutors in the UK is available in more Indian languages than the committee's deliberations. Even the invitation from the committee is available only in English. And it's shocking that the United Kingdom can have access to its resources, legal resources, in more languages than a committee set up in the 20th century to rewrite India's laws. And so that belies, on the one hand, there's this whole sort of anxiety about these laws being colonial, and yet it doesn't seem to matter to them at all that the exercise that they are planning to do is similarly limited to only a small elite segment. Now, the problem is also that because the committee has taken this exercise seemingly so in such a slapdash fashion, and that they want to do this whole process in just 6 months' time, is that 6 or 7 step process that any law reform has to have as evidence from the South African experience. Not even the first step has happened. So if you look at the questionnaires that the committee has put out, they are all generic. It is almost as if the committee is casting about for issues that it wants to examine and that it will come up with. So there are questions asking the persons who will participate in the questionnaire, what should be the procedure for introducing sealed cover evidence into Indian law? What should be the procedure? What should be the law when it comes to spousal privilege in Indian law? What should be the new rules when it comes to relevancy of evidence when it comes to Indian law? There are 2 possible lessons I can draw from the way the questions have been posed by this committee. One is, either it is a completely sham process and they already have a report ready, and this is just a pretense which they're going through in order to fulfill some sort of like broader PR exercise, or there's something more diabolic here at play, as a result of which they have thrown a few sops at progressive concerns, and hidden within this process is an agenda that is looking at entirely wrecking what little procedural safeguards there remain, given all the harm that's already been done to the criminal process through the special legislations. I've gone on for far too long. I'll just leave you with one or two examples. The Indian Evidence Act has a very carefully articulated understanding of what evidence is relevant and what is not. And a careful effort has been made to exclude evidence which is prejudicial, which has a more prejudicial effect upon a trial, which might otherwise be relevant. And that is to be found in sections 5, 6, 7, 8, 11 until 15 of the Indian Evidence Act. In one of the questions under section 11, the attempt has been made to introduce a new illustration which seeks to loosen up the rigor of relevance. Already, courts as well as the Law Commission have taken note of the fact that section 11 is in the nature of a somewhat exceptional process, exceptional provision, in as much as it makes matters which are not otherwise relevant elsewhere in the Evidence Act relevant, because they tend to probabilize or make less probable a fact an issue or a relevant fact. Through the illustration, by claiming to introduce material of a co-accused in respect of another accused, seemingly couching it in the interest of an accused, the gates are sought to be opened to all sorts of other irrelevant material, because if it can be admissible in respect of a defense, it can be admissible in respect of prosecution as well. That's one example. The other is, of course, what has been written about ad nauseum, the sealed cover jurisprudence. And this is something which from 1975 onwards, Raj Narayan's case and S.P. Gupta's case, the Supreme Court has laid down in all its well-considered decisions that the general principle must be of openness and transparency, and that there are two competing principles even where national interest is or public security is involved. One is the public interest in security, and the other is the public interest in ensuring a fair trial to an accused. And therefore, where the public interest in ensuring fair trial meets the public interest of national security, if a way must be found to ensure that the public interest of fair trial trounces that of national security. That's the words of Justice Bhagwati and S.P. Gupta. And yet now we're talking about introducing sealed cover evidence, and we're talking about loosening the rigors that exist in the Indian Evidence Act to make it easier to bring home convictions. At the end of the day, it's not as if because we often appear as defense counsel, our concern is only defense counsel. At the end of the day, if changes are brought in that ensure that the truly guilty are punished, and those who are innocent or who against whom there isn't enough evidence to reflect their guilt are not punished, we have to ensure that that process happens. And that process is already at serious peril because of the special laws. That process is going to be wrecked even further by any report this committee gives. So I'll end there, and I'll take questions later on once. And I'm sorry for having wildly overshot my time. Sorry, Rebecca, for eating into your time.
Thanks, Jawahar. Also, I've been remiss and haven't told people that if you want to ask questions, you can add questions onto the YouTube channel, and it'll be fed through over here onto our platform over here. This is also being streamed live on Instagram and other platforms. So thank you for that, Jawahar. And next up we have Rebecca.
So I don't want to repeat what Jawahar has said, particularly with respect to the composition and the manner in which the Law Reforms Committee came into being. Since I was a part of a group of people who actually attempted to answer the questionnaire, I will focus on the questions asked, the questions not asked, what they could have asked but did not ask, and whether any of those questions were dangerous and frightened me as a criminal defense lawyer. There were a set of questions which are of particular interest to me, which were asked. Some relating to plea bargaining, some relating to forensic science, some relating to sentencing, punishment, videography, and sealed cover jurisprudence. So I'll take them one by one. And I'll start my address with the questions relating to forensic evidence. And this seems to have received a fair bit of attention by this committee in the questionnaire sent to us. Essentially, the committee seeks to expand the scope of Section 45 of the Indian Evidence Act to other areas of forensic science. And there seems to be a mindless process where several forensic sciences are sought to be brought into what we call admissible evidence. Now, look at the nature of some of these questions. For example, there was a question which said, please suggest measures to enhance the reliability and credibility of experts and expert evidence. The question betrays a fundamental lack of understanding of how this evidence should be viewed by a court of law and how international jurisprudence or international courts view scientific evidence. It betrays an understanding that science is not free from error and that on many occasions, scientific evidence has been proved to be wrong. So there's nothing sacrosanct about scientific evidence. And in one of my responses, I wrote, and I will quote, that last year Murphy published a book called Inside the Cell, The Dark Side of Forensic DNA, which recounts dozens of cases of DNA typing going terribly wrong. Some were close to farce, such as the 15-year-old hunt for Phantom, whose DNA has been found at about 40 crime scenes in Europe in the 1990s and early 2000s. The DNA in question turned out to belong not to a serial killer, but an Austrian factory worker who made testing swabs used by police throughout the testing swabs used by police throughout the region. And some are tragic, like the tale of Dwayne Jackson, an African-American teenager who pleaded guilty to robbery in 2003 after being presented with damning DNA evidence and was exonerated years later in 2011 after a police department in Nevada admitted that its lab had accidentally swapped Jackson's DNA with the real culprits. Then there is this whole question of evaluation of scientific technique, foundational validity, and valid application, which seems to have missed Indian courts and the manner in which we examine forensic evidence, and it was not particularly evident in the nature of questioning. Foundational validity for a forensic science method requires that it is shown, it is based on empirical studies, it is repeatable, it is reproducible, it is accurate at levels that has been measured and are appropriate to the intended application. Foundational validity means that the method can, in principle, be reliable. So before you introduce forensic science and before you introduce more and more forensic techniques, it must cross the test of foundational validity. Otherwise, Others versus State, in which Mukesh was ultimately hanged. This is the one of the Nirbhaya accused. The Supreme Court relied erroneously on the odontology report and found the accused guilty. Now, 2 paragraphs from a commentary were reproduced in the judgment, which merely explain what odontology is. This is despite the fact that forensic odontology has now widely come to be regarded as junk science. Further, the judgment stated that the report had been prepared on the basis of comparison of photographs of bite marks. Now, research has now indicated that forensic odontologists could not arrive at a consensus by looking at photographs as to whether the bite mark was even human or not, let alone match it accurately. Now, astonishingly, as late as December 2019, the Supreme Court, in a suo motu case, assessment of the criminal justice system in response to sexual crimes, in its order dated 18/12/2019, has gone on to state that forensic odontology is essential in rape cases. And I quote, it says, forensic examination and report play an important role during the investigation as well as trial for linking the culprit with the crime. With the advancement of the DNA science and its accuracy, the sampling for the purpose of forensic examination and expeditious reports after due examination are vital to the just adjudication of the case. The sampling for the purposes of DNA tests, as well as other forensic science, like forensic odontology, is essential in cases relating to rape. The apex court, in issuing the above directions, seemed unaware that forensic odontology has been internationally discarded as a scientific technique and of the dangers of over-reliance on DNA science and its accuracy based on readily available international scientific research, data, and findings to the contrary. So these questions, which they asked, and as I said, the over-reliance on forensic techniques was also based on that fundamental lack of understanding about errors in these sciences, about sciences which have been junked internationally as junk science. And you continue to rely on these sciences, and you're asking questions about these scientists, basically to allow you to convict people on these forensic sciences. There was also a lot of questioning on emerging forensic technologies, especially in the field of facial recognition, biometric analysis, artificial intelligence, etc. And again, whoever wrote these questions seemed to be overawed by these catchphrases, but had very little understanding about how the research internationally was, what the research internationally was telling us about these techniques. Furthermore, and I think this is where courts in India fail, and the questionnaire failed to identify that failure, is the fact that experts come to court without making a fair disclosure of their operating protocols and operating procedures. So I've spent a fair amount of time answering these questions, and I've asked for national protocols and national guidelines to be put up on the websites of each of these forensic science laboratories so that we can question them about their relevance and foundational validity. Every test must be of the kind that will match international standards, which is capable of replication and which is capable of being questioned robustly in a court of law before it is admitted. The fact that you're asking all of these questions in a country like India, where there are exactly 6 central forensic science laboratory, 1 central FSL attached to the CBI, and 32 forensic science laboratories across the country. What is the relevance of asking these questions when you don't have the infrastructure or the trained personnel to conduct forensic science examinations? And clearly the state is not interested in improving or in having more forensic science laboratories across the country. Then there was this very ambitious question which was asked about the Dobot test, which is applied in the United States, the 5-prong test called the Dobot test, which is all very well. But the Dobot test is based on the premise that there is empirical testing, peer review application, error rate of the test, maintenance of standards, and general acceptability. Can you have, when we talk about the Dobot test, do you have a parallel to Rule 702 of the US Federal Rules of Evidence in India? You don't. So why are you asking these questions simply because you read about it somewhere and think that it can be transposed into the Indian setup? Likewise, there was a lot of questioning on cell phones, on facial recognitions, on passcodes, without understanding the direct breach to the fundamental right of privacy and how investigating agencies should not be allowed to compel accused persons to give their cell phones or to give their passcodes or passwords without following procedural safeguards which are embedded in the Code of Criminal Procedure, for example, Section 91 of the Code of Criminal Procedure, where you have to pass the relevancy test before you can ask for a particular document or thing. So again, over-reliance on forensic science. There was also a lot of questions that related to sentencing. There were questions related to punishments, some of which were interesting. I will not say that they were not important questions. For example, there was a question: should sentencing guidelines be framed to control disparity and bias in sentencing in India? What should be the constitution, powers, and frameworks for the authority which would frame such guidelines? fact that arbitrariness, disparity, and bias, and the wide range of punishments within an offense needed to be addressed was perhaps recognized in this question. And some of us did recommend that to reduce disparity and bias in sentencing procedures, it must be ensured that there is certainty in procedure as opposed to certainty of outcome. And we recommended the setting up of a sentencing commission in India dedicated exclusively to the task of formulating sentencing guidelines, which is urgently required, based on, of course, much wider consultations with legal practitioners, researchers, academics, judges, mental health experts, etc. There were some questions relating to mandatory pre-sentencing hearings, which I think was an important question to ask, because we should have mandatory pre-sentencing hearings, which should be evidentiary in nature rather than oral hearings. And an attempt was made to go into that space. Whether or not they gave us the space, our answers, of course, were very, very robust, I hope. And we introduced the concept of having mandatory sentencing hearings based on evidence, particularly in the more serious offenses where people are either given life imprisonment or the death sentence. It is it's important to recognize the fact that even in death sentence hearings, we do not have evidentiary hearings where a person can lay out the mitigating circumstances, both with relation to the crime as well as to the criminal. So when you talk of aggravating and mitigating circumstances in the appellate court, there is no foundational basis for it because there has been no sentencing hearing which lays out this as evidence. There was another interesting set of questions on plea bargaining. Again, completely based on a lack of understanding of the ground realities, the social economic ground realities in India. And the questions really was how to make plea bargaining more effective, to increase the efficacy of the plea bargaining system. Should there be a separate authority to be constituted for the conduct and supervision of plea bargaining cases? Some of us had a fundamental opposition to these questions because the concept of plea bargaining ignores the harsh socio-economic realities of the Indian criminal justice system. Quality legal assistance comes at a cost, while the poor and the marginalized accused, which the poor and the marginalized accused are unable to afford. A poor, barely literate accused who has entered the criminal justice system for the first time is bound to be overwhelmed by the process and might be pressured or coerced into plea bargain, regardless of whether or not he has committed an offense. Now, in our own internal discussions, some of us asked the question, as counsels, would we advise a rich corporate client to plea bargain? And what would that rich corporate client's answer be in such a situation? Clearly, he would say, I will contest. Whereas plea bargaining would be thrust on the poor, more vulnerable people who are incapable of contesting the case, even if the case against them is weak and should be thrown out. And one of the interesting developments which I have been part of is the mass plea bargaining exercise, probably the largest plea bargaining exercise, which was conducted in Delhi recently, where over 900 foreign Tablighi Jamaats pleaded guilty to a crime which perhaps the prosecution was unable to prove, but did so because of force of circumstances. They were in India for over 4 months. They needed to go back to their home countries, and they thought this was the best way to exit the countries. So somewhere the morality of these questions also need to be questioned. Do you have an understanding of where this plea bargaining comes from? Do you have an understanding as to who are the people you are seeking to address? Originally, when plea bargaining was brought into the Code of Criminal Procedure, one of the stated objectives was that it would reduce pendency in courts. Now, that can't be the moral objective of any law reform process. You want to reduce pendency in courts, you throw out the large majority of cases which are unsustainable. But you don't thrust plea bargaining proceedings on individuals who have no option but to take it simply because they neither have the means or in the case of the Foreign Tablighi Jamaat, the time to resist such proceedings. So that was another section which we answered. I know Jawahar has spoken about the sealed cover jurisprudence, which was asked. It was actually quite a shocking question. The question, and if I can quote it, should the Indian Evidence Act provide guidelines for the admissibility of sealed cover evidence in judicial proceedings? If yes, please suggest the same. Can the Indian Evidence Act, I mean, assuming that sealed cover jurisprudence is something that will become admissible evidence, can the Indian Evidence Act give guidelines for anything? The Indian Evidence Act is an act which lays out sections for the relevance and admissibility of evidence. It can't give guidelines. It is not a handbook to be given to judges to guide their discretion. And most of the questions were prefaced with this word, with this phrase, can you give us guidelines to help judges formulate their positions? Guidelines are something that you give in handbooks. They can be part of a high court's procedural rules, high court's rules and orders, but they cannot be part of statutory formulations. And to ask a question in a law reform process, like can sealed cover jurisprudence be made admissible, I think is very, very immoral and is a question that should never have been asked. Because what is a criminal trial except fair disclosure of facts to an accused person? An accused person must know what he is facing. An accused person must know what he has to defend. And the charge has to be cogent and relevant. And if all of this is put in sealed cover, how does an accused person defend himself in a court of law? So this question was an immoral question. It should never have been part of the questionnaire. And it's extremely strange that a committee formed within a law university should have asked a question such as this. There were some questions that were asked which were again interesting, but there were no follow-up questions to them. For example, there was this whole section on illegally obtained evidence, which is really based on the American jurisprudence of fruits from a poisonous tree. Now, asking that question is all very well, and it's also very easy to answer that illegally obtained evidence should not become admissible in evidence. But where are the follow-up questions where you tell us how procedurally the trial will change, the structure, the architecture of a trial will change? Because in America, as you know, these become relevant at the pre-trial stages. There are special evidentiary hearings for admission of evidence, and obviously evidence which is illegally obtained is discarded from consideration. We don't have those procedures architecturally in India. So simply asking this question, it appeared to me that some person had read it at the time and found that interesting, but did not ask the parallel question. So how do I introduce this within the Indian legal system? All in all, the exercise has been quite fascinating. The questions asked and the questions not asked. There were several questions that were not asked. I'll save that for my interaction with Mayur later. But the questions asked were strange because, as I said, there was an overemphasis on forensic evidence without a parallel understanding. There was an attempt in some cases to ask the right questions, for example, in the sentencing chapter, as well as in the punishment chapter. Again, there were questions asked which could really throw us off. For example, the questions relating to sealed cover jurisprudence, as well now at the end of this process, I have no idea whether our answers will be considered. Let me also say the only reason I decided to answer this questionnaire was because I wanted my answers to be treated as dissent for whatever was coming, to be treated as a record of what could be the correct and moral position. But at all times, we prefaced our answers with our protest that this was not the way to undertake a law reform process. And we also cautioned the committee not to recommend anything without a much wider consultative process with more stakeholders, trial court lawyers, academicians, mental health experts, and others, judges and others who have a stake in the criminal justice system in India. Thank you.
Thank you so much, Rebecca, and also thank you so much for taking part in the questionnaire process, because there's so much of fertile room for just queries into the criminal justice process, into the process of law reform, and I'm really looking forward to understanding what questions you think they should have asked but haven't asked yet. But I think your final, and there's some questions popping up on the Q&A which I'll come to in a bit, but I think your final statement about exercising, registering your dissent in how the process happened, and that a more robust process needs to happen, kind of takes me to my first question to Jawahar. So I guess, Jawahar, just to play devil's advocate over here, is you have this committee, you have this process of law reform that's being undertaken right now. And let's say you have to do it for whatever emergency situation. What would law reform look like to you at this present moment, in the context of a pandemic, in the context of, let's say there is an emergency with the criminal justice process in India? What should that process look like? Or what could it look like for you?
Well, let me first say that for legislating or going through a law reform process in the middle of a pandemic, there has to be good reasons for why that process cannot await the end of the pandemic. If you're going to rewrite the law on sexual assault in order to take into consideration the concerns of transgender persons and people from across the gender and sexuality spectrum, there has to be space for you to interact with the people who have faced already the brunt of the horrors of the criminal justice system. If you're going to look at rewriting those laws, and if it has to be done, it has to be done in that fashion. And I can't see why that cannot await the end of this pandemic, so that you can have a proper consultative exercise. Like I said, these three laws have gone through several revisions already. These three laws require many revisions. There are several law commission reports that exist already that point to specific gaps in these laws that need to be filled. Even there, I would say this is not the time to go ahead with this process, because those law commission reports, some of them were written without proper advertence to the communities that are going to be worst affected by it. Therefore, until there is something like a public health emergency, right? We've lost about 1 lakh of Indians since March. That's ridiculous. I don't know any other war battle that India has been in that has taken so many lives in so short a span. If we've lost 1 lakh of Indians, and if we know that, and for many of us middle class people, perhaps life has returned to some fashion of normalcy, we're able to conduct our court hearings online and so on. But for many people, and these are the people who will face the brunt of the criminal justice system, they are in no position to be able to be thinking about how the law ought to be changed. Therefore, it is immoral to be doing this exercise in the middle of a pandemic, right? So that being said, this the fact that the law needs reform is a given, and there is enough expertise, there's enough experience about how such law reform ought to happen. The problem, and I'll pick up from what Rebecca has already told us about the questions, is that there is a complete lack of a central organizing principle behind these these 6 sets of questionnaires. There is no broader social understanding of what are the problems that are faced, and this I think has to come with the fact that it's not as if the exercise is being carried out in response to demand saying we want this, and this to be changed. Let's remember that it is fueled by the Home Minister making a statement in November of 2019, where he says that, look, these are colonial laws. We need to change them. And again, taking a cue from what Rebecca says, his whole imagination is of scientific evidence. And I believe one of the speeches he said that once, if we have scientific evidence, then why will we have so many acquittals? So long as we have scientific evidence, we can have convictions, and that should be the end of the matter. This is pardonable in somebody who has no acquaintance whatsoever with the way criminal process is supposed to happen. If you believe that these technocratic solutions by introducing new kinds of quote-unquote scientific evidence, and as Rebecca has pointed out, there are the Western liberal jurisprudence littered with this kind of junk science, whether it's odontology or whether it's all other kinds of junk science. And so you assuming that by introducing this new baby of shiny little baby of scientific evidence, you're going to be able to cut short the problems of the legal process is the fundamental flaw, accompanied by the fact that there's a complete lack of understanding of the social world of criminal law. And also, what is shocking is there seems to have been absolutely no background effort on the part of the committee. Right? The questioners are littered with questions that seem as if it is a student sitting in her second year of in a law program asking questions. Do you think 65B should be changed? If so, how should it be changed? Do you think there should be new guidelines for how expert evidence ought to be introduced? If so, what are those guidelines? Well, that process is something which this committee ought to have done already. Instead, if you examine the committee's website, they have put up a separate sort of folder of their resources. What are their resources? 89 law commission reports and 35 articles. All 35 articles written by the one member of the law commission who is of that committee, who's a convener. 35 articles written by the one person who's a committee, and 89 law commission articles have been dumped into that repository. And this is the extent of the research. And so therefore, one of the questions that went from the judges to the committee was, surely you have done more research than this. But if you look at the questions, it betrays the fact that they've done absolutely no research. Some of the questions have been lifted from the law commission reports because the law commission report suggested a particular formulation 40 years ago and has been posed as a question. Others are literally what a second-year student has opened up the CRPC and said, oh, let's look at, perhaps we can think about moving sexual assault out of the chapter on causing harm to the body into a new chapter. Oh, let's think about, are mandatory life sentences, the life for life sentences, are they opposed to the idea of reformative justice? Well, that's a broad philosophical question that is absolutely inane. The answer that can only be yes. But beyond that, what? So what? I mean, whatever problems one might have with the quote-unquote colonial legal system, there is a central organizing principle. It is broadly around harm to the person and emanating out of the harm to the person. What is that? What is the organizing animating principle that you're looking at? That the committee is ignorant of, because I suspect they have no interest in, because their report is a foregone conclusion. They're going to write what the Home Minister wants.
Thank you very much. So one of the things that struck me about both your presentations is that this idea of experts comes into play, right? So the first iteration of the law of this committee's consultative process was sending it out to experts, as you pointed out. So I guess, again, just to kind of play devil's advocate a bit, what is at stake in a public consultation? Why can't we just have people with the know-how of dealing with the criminal justice system to just to give us what is wrong with it and the solutions to it? But why should we involve everyone?
Is that to me?
Yeah, Jawahar,
yeah. No, so I think why we should involve everyone is because even experts come at it from their specific lived experiences, right? So whether it is as an expert lawyer or as an expert forensic scientist, the level of your expertise, quote unquote, is limited to the sampling of the clients who come to you. It is not the experience of the person who herself is suffering the consequences of that law. Either the consequences of an under-inclusive law, which allows for certain kinds of violence to go unrecognized, or the consequences of an overbroad law that allows for otherwise unexceptional behavior to be punished merely because of certain outmoded idea of morality being imposed upon her. So it is important for that reason, because the criminal law affects everybody, because the criminal law is meant at the end of the day to tell you and me that A, B, and C is forbidden. Everything else is open to you to do. So it is important that that there is a broader process of deliberation in which we come to an understanding that yes, we have understood that this is the way in which that these acts must not be permitted. These acts amount to incitement to particular kinds of activity. Therefore, we are going to forbid them. We've seen how the Supreme Court today is struggling with trying to come up with a formulation that respects the right to freedom of speech, as well as comes down upon incitement to hatred, discrimination, and violence. So we've seen how difficult it can be, even at the process of experts. But I think, therefore, to take on board the important lessons from the South Africa type experience of trying to translate what the law finally means and how it's going to impact, what it's going to forbid and what it's going to permit, and also what are the safeguards in place to ensure that persons who are genuinely guilty are actually meet the punishment and meet an appropriate and condign punishment, and not something which is excessive. Right? So these are meant to be carefully calibrated. Experts have a very important role to play in this, but experts cannot be the sole domain. They don't have a monopoly on wisdom in this aspect, in this sphere. It is important everybody has a say in this, and therefore the importance not just that all must participate in this process as feeding into it, but also that the committee itself must represent a broad span of society.
Thanks, Jawahar. So this kind of brings in another question about experts, and Rebecca, ma'am, if you could come in on this. So the idea of forensic evidence, as Jawahar said, it's like a technocratic idea. You have the belief is that science will provide like a silver bullet to decide who's guilty and who's not guilty. Could you just tell us in kind of very basic terms, what's the danger in that?
So firstly, we must understand the Indian law and the position that the Supreme Court has taken on the issue of expert evidence from the beginning of time, of at least of our constitution. Expert evidence, handwriting evidence, back in the day in the 60s when that Constitution Bench judgment was given, there was only handwriting expert evidence. And they said it was corroborative evidence. It was not substantive evidence. So let's be very clear that any expert evidence, it's opinion evidence, it is corroborative, it is not substantive. And that is why in many judgments of the Supreme Court has gone by the oral testimony of witnesses rather than, say, the finding of a postmortem doctor, because they found the postmortem evidence to be flawed. So expert evidence is just one piece of evidence which can come within the ambit of a criminal trial. It is corroborative, not substantive, and therefore it should remain in that category. Now, what you're trying to do by introducing these new kinds of expert evidence, and really it's all shrouded in secrecy. It sounds very fascinating, and so everybody says it must be right because it has this long name, and clearly I don't have any understanding of it. So how do I question it? But the point is that with the use of technology, there is also the issue of vulnerability. Not everything can be admitted in court unless, as I said, it passes the test of foundational validity. For that, the expert evidence needs to be scrutinized with care, a thing that doesn't happen very robustly in India, I'm afraid, because the minute you say there is forensic evidence with respect to handwriting or voice sampling or anything else, it's kind of treated as though that's the end of the matter. Whereas all across the world, it goes through a very, very stringent, robust process before it is admitted in evidence. So I think this, as Jawahar rightly said, I think this over-reliance on expert evidence is because you don't understand the law, you don't understand the science, you haven't seen how international research has progressed on the subject, and you're trying to thrust something. Remember the time when we had a narco-analysis masquerading as expert evidence till finally everybody understood it was mumbo-jumbo science? So it is important for us as we see the use of technology, it is important for us to test its foundational validity. And that critique was missing because they lacked the understanding, is my belief from a reading of the questions. No harm in introducing expert evidence. In a given case, it could be very, very valuable. But unless, as I said, transparency in protocols, foundational validity, I've had cases where a particular laboratory has said, I am not able to extract the DNA from it because your sample is insufficient for us to extract DNA. The police quietly goes to another laboratory and gets exactly the kind of report they want and conceal the fact that the original laboratory to whom they had gone to had refused to, or had given them an answer that this sample is not capable of anything being extracted from it. So our processes are opaque. We need more transparency. We need to put up these protocols, the manner of collection, the putrefaction that happens in samples. There are a lot of complex things here. And unless you have an understanding of that, merely saying this is expert evidence, therefore the case is solved, is really being very foolish.
Thanks for that. There's a question from Suvedya Reddy, which I think pertains to this. So I guess one of the problems or the issues that come up with thinking that there's some forensic evidence which is not junk science and some forensic evidence which is junk science, right? Does it point, and as she puts it very correctly, is that all scientific evidence tests themselves have many lacunas, right? So is the argument against scientific evidence in its entirety, or is the argument against certain types of scientific evidence?
Not at all. The argument is not against scientific evidence. The argument is the nature of its admissibility and what role it will ultimately play. So there is a reason why Indian law has said it is corroborative and not substantive. If you have other evidence which corroborates the scientific evidence, go ahead, use it. And I'm not for a minute suggesting that all scientific evidence is junk science, not at all. But have the process, like we should have a parallel of Rule 702 in India, where you go through those evidentiary standards and only then admit it in evidence. And also, where is the harm if these forensic laboratories tell us in advance, these are the tests, these are the protocols, these are the rules, this was the manner of collection. If that is, there's no transparency in our procedures. And if those transparencies are brought into scientific evidence, in a given case, it can be invaluable to judge the criminality of the allegations.
So I have a slightly speculative question for you then. I mean, you told us about how the questionnaires were a mixed bag, some of which are troubling, some of which came out of the air, some of it was pointless, some of it was ignorant. So there are various things. I didn't know about the sealed cover jurisprudence. That kind of shocks me that you could be convicted on secret evidence. But elsewhere, you've spoken about the strict liability offenses. Right, and so strict liability offenses coupled with sealed cover jurisprudence, coupled with this imagination of scientific evidence being the silver bullet. Where do you think this committee is heading in terms of its final report? We all know that we can't speculate on what they'll do with the questionnaires answers, since that process, as Jawahar's pointed out, is very opaque. But if you could speculate on where you think they're headed towards, what's the end point you think they're going to reach?
Actually, Mayur, I don't even know whether these questions and these answers have any meaning. I don't know whether this is a camouflage for something else. I have no idea. Nobody is telling me that whatever is going to be recommended by this committee based on the questions and the answers, assuming that we have a fair description of both, is what is going to be accepted by the ministry. We have no idea. So where is the prohibition from of the ministry deviating from any recommendation made by the committee? So all of that is shrouded in mystery. I don't know where this is heading. I can only say, on the basis of the questionnaire process that I participated in, that some of the questions, for example, the question you said about strict liability. Now, who in their right mind would ask a question like this? Which principles regarding the object and nature of crime should guide the introduction of strict liability offenses within the IPC? IPC offenses, one of the principal elements in IPC offenses is mens rea. And it completely contradicts the position of strict liability offenses. They're two opposite, they're poles apart. Now, are you trying to say through this question that mens rea or intention, the mental state of mind, is no longer sufficient or is no longer important to determine whether a person has committed a crime or not? And if that is what you're going to say, and this was your first question, then I would say we're looking at very troubled times. Of course, after that, they had other questions. They did a balancing act. So where they talked about fruits of a poisonous tree, it was a standalone question. I have no idea how it will be applied. So yes, the question pertaining to strict liability, that entire lot of 3 questions, were a bit scary when you're dealing with IPC offenses. These are not technical offenses. You're not dealing with the Negotiable Instruments Act or the Prevention of Food Adulteration Act. These are offenses where intention and mens rea is a necessary requisite for the offense to be complete. And for the first question to be that should we have strict liability offenses in the IPC, I think was very, very frightening.
Yeah, and I was just thinking, the point you made elsewhere, the fact that this committee is only looking at IPC, CRPC, and the Indian Evidence Act,
yes.
Whereas as we know, the most of much of criminal law litigation right now is under special legislation. So this idea that you already have some form of strict liability in the UAP, for example. Yeah, so that combined with these questions gives me pause.
So it's interesting because their public notice dated 8th of July 2020 said that the mandate of the committee was to recommend reforms in the criminal laws of the country. Now, criminal laws of the country are not limited to these 3 statutes, right? And therefore I said, I am also going to be talking about the questions they did not did not ask, because if you are looking to recommend reforms in the criminal laws of the country, how is it that you have completely ignored the large majority of special acts today, which have become the norm? In fact, general law, the IPC, Indian Evidence Act, CRPC, have all been diluted in the special acts, and where the citizen faces the brunt of that dilution, because you've diluted procedural law, you've diluted evidentiary law, you've enhanced punishments, all of this because you want to make somebody as the enemy of the state. So if you were a genuine law reform committee, and your stated objective is to bring in reforms with respect to the entire spectrum of criminal laws, how is UAPA not part of it? How is MACOCA not part of it? How are laws like PMLA not part of it? Where you have restricted liberty to such an extent that it is virtually impossible for an accused person to come out while the trial is on, where you have extended the periods of remand from 90 to 180 days, which is a deviation from procedural law, from the CRPC, where you have virtually made it impossible for someone to come out on bail, where evidentiary standards are not the evidentiary standards that you see in the Indian Evidence Act. How is it that this committee has not engaged with some of those more pressing pieces of legislation, which I may say today actually rules the space? The IPC doesn't rule the space. It is these special legislations which are being invoked time and time again, and almost against the constitutional scheme. These special legislations largely are unconstitutional, illegal, and have brought in immoral provisions against the citizen. And it completely baffles me, or maybe I shouldn't be baffled, that this is not part of the reforms that they are talking about, where law is now treated as an instrument of oppression. So clearly, the committee doesn't seem to be engaged with that part of criminal law.
Thank you. So we have several questions on the chat about.
May I? Yeah.
Yeah, sure.
I just sorry. I know I've been talking more than my fair share of but I just wanted to add to what Rebecca said about how is it that what initially began as a process, or at least in one iteration seemed to be a rewriting of all criminal law, suddenly becomes about these three codes. And then when the critique happens saying that, look, how can you do this in the middle of a pandemic? How can you do this without broader consultation? The press notice put out saying, no, we've tied up with several organizations and therefore we're doing public consultations. At one of those public consultations, which apparently was a 2-day process conducted at NUJS by some Society for the Advancement of Criminal Justice, apparently the topics for discussion were amendments required in these three codes, then police reform, juvenile justice reform, restorative justice, amendments required in drug trafficking. I don't know what drug, so they want to amend drug trafficking, arms trafficking, human trafficking, female criminality, honor killing, cyber crime, correctional services. So that 2-day process apparently involved almost everything. If this is not vague enough, then they had another process in Gujarat, at the Gujarat Law School, which is a 2-page questionnaire. Do you think Indian criminal system requires reforms? Yes or no? You can check the box. If yes, in your opinion, what are the different criminal laws that require reforms? What are the different sections of different legislation that require amendment? Kindly specify reasons for suggesting amendments to the above mentioned sections in a few words, and that's it. This is the type of questionnaire in response to critique that, look, this is not robust enough, this is what they intend to do. And to link that again with the question of strict liability, this is the same government that has completely suffocated what possible provisions there were for enforcing labor jurisprudence, right? So in labor law, what provisions there were clearly not sufficient because you required the labor inspector to go and prosecute. Instead of strengthening that and ensuring that at the very least that the terms of a contract of labor are put up in an industry to ensure that everybody is paid their salary or within 7 days time. If there's a space for strict liability, perhaps it's in that regulatory sphere. In the rest of the world, where is strict liability brought in? It is in regulatory offenses of this nature. Why is it that at the same time as you're snuffing out any possibility of prosecutions, doing away entirely with prosecutions for violations of labor law, you are talking about introducing strict liability into the IPC, which typically is meant to envisage a completely different kind of offense. And this brings me back to what is the animating principle behind this whole process. When the Home Minister announced this process in November, he announced it in Lucknow. At the same meeting where he said, we are going to rewrite these three laws, he congratulated the UP government on its quote-unquote law and order improvement. This is the UP government, which I think in January of that year had killed something like 3,000 people or something in encounters. Right? So this is what is under the understanding of law and order for this government. This is what is the understanding which seemingly has percolated to this committee in terms of what is a fair, just, and appropriate criminal justice system.
Thanks, Siobhan. And I think that kind of segues into some questions that are coming up on the chat, which is about obviously the recent rape and murder of a person in UP and the cremation, the clandestine cremation by the UP police of the victim of that rape and murder. So I guess, the questions are, how do we respond to gender-based violence? Can we please address violence against Dalit girls? So I guess my question to both of you is what bearing do these incidents have, or what should these incidents tell us about the process of law reform? Obviously, there is some process of law reform needed, but can we amend the criminal law how do we amend the criminal law given these things are happening?
So let me just take that on. What has happened in UP and what is happening again today, there have been more incidents. It's been quite heartbreaking, very, very painful to see. And it's not enough to just ground it or focus it around the issue of gender. It is also caste related. And unless we recognize that reality, we will not really be understanding what is happening on the ground. already I have heard news reports which have come out, which are saying that the UP police is saying there was no semen detected, and etc., etc. So they are trying to take this outside the scope of race. They are denying of rape. They are denying that there was any caste-based crime involved, and so we can pretty much see where this is going. However, whenever something as tragic as this incident that took place 2 days ago happens, there seems to be this this response from us that the law must change. The law did change in 2013, and I always respond by saying that actually there's nothing wrong with the law. It is the application of the law on the ground which is so faulty and which is so problematic. When you have a police force which is so compromised, when you have an establishment which doesn't see what is happening, which tries to clandestinely, cremate a rape victim in the manner that they did 24 hours ago, then it's not the law which is at fault. It is the implementation which is at fault. The people who are meant to uphold the law are not upholding the law. And that is really where we should focus our energies to. Every time I hear this cacophony, let us change the law, let us do this, everything should become punishable with death. It doesn't solve anything unless we realize how compromised the police constable on the street is and what pressures come to bear on him for what he does. You can't look at him and make him the enemy, because clearly he's acting under political instructions. And when he's acting under those instructions, this is what happens. So I think we need to direct our outrage towards those issues rather than say that the law must be amended. Amended to what more amendments can take place. Of course, law is an evolving process, and over a period of time, we can always look back and see whether we can make corrections or not. That apart, the answer is not that the law must be amended. The answer is the people entrusted with the task of implementation are complicit and are making women more and more vulnerable, are making people from vulnerable sections of society more vulnerable, and so that is really the focus of that should be the focus of our attention, rather than asking for tighter laws, because I think the law is as tight as it can be.
Thanks. And I think also the question of law reform implies that, as you rightly pointed out, that the police aren't compromised, or that, and the questions seem to be going into a zone of, or the questionnaires seem to be going into a zone of authorizing or giving more authority to the state, giving more authority to the judges, giving more authority to the police, giving more authority to the expert, where in effect they are part of the problem. In cases such as the tragic incidents that we saw earlier, a couple of days ago. Jawahar, did you want to come in on this question?
Just to, to pick up from what Rebecca said, to link it with the seemingly innocuous sort of like throwaway to the progressives, fruit of the poison tree sort of idea, the jurisprudence, that has always been different about UK and Indian law versus US law, right? That the fruits of the poison tree have been understood and applied somewhat stringently in the US, and in India, how you obtain evidence is irrelevant. And broadly speaking, with a few exceptions, how you obtain the evidence is irrelevant, so long as it is otherwise relevant to the trial, right? And once you introduce ideas or you lift them out of a completely different ecosphere, and you try to supplant them in a sphere where this has never been part of the understanding, it's going to, at the very least, you're going to have to actually think about how it is that it's going to fit in within the broader sphere of how we think about trials in India, right? And given how prosecutions work as well, because we, as I said, we are not concerned merely as defense counsel, but we're also concerned that those who commit crimes ought to meet their just deserts. And the just deserts must mean in cases like we've seen in the past few days that the correct person is punished appropriately for his or her offense. And in that, it would be short-sighted on our part to actually get seduced by the idea that this committee is throwing at us the idea of the fruits of the poison tree because, oh, perhaps there are some progressive initiatives as well wrapped up in this, because I suspect that they've not thought this through. And no matter how it is, if it is introduced in this half-baked sort of fashion in the system as it exists, it's going to result in even further deterioration and crumbling of an already broke system.
Thanks. So we have about 8 more minutes. I just want to, so we've gone through kind of the process, the substance of it. I'm just curious about the politics of it. Why do you think, obviously we don't know what's happening in the Home Minister's mind or what's happening in the chairperson, the committee's mind, but why do you think this committee has been set up now? What's behind it? Either one of you, Jawahar or Rebecca?
I don't know, but I do know that wherever I go, whichever seminar I address, the underlying theme is how can we get more convictions? And the low conviction rate is something which troubles everybody, and therefore you throw expert evidence, you throw this, you throw that, you seek to give more power to the court, to the expert, to the prosecutor, to everyone else. So there seems to be an underlying concern among senior police officials within the political establishment and elsewhere that the conviction rate in India is very low. Now, that is not going to change because you make these artificial changes to the law. You have not invested in infrastructure. The judge litigant ratio is skewed against the litigant. We don't have judges, we don't have courtrooms, we don't have materials for judges so that they can read and can be abreast with the law. Even with respect to forensic science, you've asked all these questions, but I said there's one central forensic science laboratory in the country, one attached to the CBI, and 40 state-level forensic science laboratories. Where are you going to go? Where is the investment which you have to make in the system? So it's all very well to say conviction rate is low, the system is broken. Who's responsible for it? We keep hearing conversations both inside and outside courts about the high pendency rates. Well, let me ask you a very basic question. Why is the pendency so high, aside from all the other obvious reasons? It's because you have case after case, meritless case after case, occupying the board of courts for years on end. Why doesn't someone do an audit and throw out those cases? No, but you will keep it on board because you have this idea in your head that this man should be punished. For example, in a large majority of mid-level CBI cases where they prosecute mid-level traders and businessmen for crimes under the Prevention of Corruption Act, for taking loans which they have not repaid. There may be some complication with respect to their documentation. I'm not saying that they're above board. But at some stage, these people pay back the loans with interest, and the bank says, we don't want to prosecute them anymore. But the state does not withdraw prosecutions. Why are we so obsessed about prosecuting people? And that obsession seems to have grown leaps and bounds now, where everything is a crime, where I need actually to know what is not a crime anymore, rather than be told if you are safe if you don't commit X, Y, Z offenses. Today, everything is a crime, and I think somewhere this seems to have overtaken everything in our country, where we want to have more and more convictions. And one last thing, sometimes the ends of justice can be served even with an acquittal. Somebody who's wrongly framed, the ends of justice is equally served with an acquittal. So we must not look at convictions and conviction rates in this kind of narrow space without looking at all the accompanying things which are necessary to make the system a far more accountable system.
Sorry, thank you very much, Rebecca. Jawahar, did you have any final thoughts?
I mean, just to hazard an answer at your question, I think, and to follow on what Rebecca said, I think I will see it as part of a larger process of concentration of not just wealth but of power, and this we are seeing in the way the laws are being changed across the board. Whether it is the environment impact assessment, whether it is labor laws, whether it is the farm bills, the idea is to allow for greater concentration of wealth and for greater concentration of power. And towards that end, it suits the powers that be who today hold a massive majority to have a system that is completely arbitrary. So if the system that is already largely broke is broken even further, and what little safeguards that exist are whittled away, and you're left entirely at the whims and the discretions and the caprice of the powers that be, it works very well, because then that allows for more power to be concentrated in the hands of the few who are able to command somehow these vast electoral majorities. The only sense of hope, I suppose, is that Indian society has previously found ways of even bringing such massive electoral majorities to cutting them down to size. It was Rajiv Gandhi's government. We remember quite well. We remember that our predecessors, Rebecca and her colleagues, who ensured that the TADA was made to lapse. And that the worst effects of quota were kept out of the UAPA. And so I think there's an important lesson in that for the powers that be, that even such massive power will someday give way to, and you will find yourself at the wrong end of power. And there's a lesson also for us, that even in the face of such massive power, it is important that we continue to speak, to use the well-worn cliche now, truth to justice, and we continue to point out that these are flawed, arbitrary and immoral processes, and we must resist them right now while the committee is in process, when the committee sends its report, when that report reaches Parliament, and when Parliament attempts to pass.
All right. Thank you very much, Jawahar, for that final inspirational and hopeful point. We're well past the time for this seminar. Thank you, Jawahar and Rebecca, for organizing this. Thank you for LiveLaw for hosting this. And thank you for all the questions. I'm sorry that we haven't been able to get to all of them. But you can find the discussion, if you found it fruitful, on the LiveLaw YouTube channel. Thank you very much. Oh, Jawahar, last point.
Just a quick plug. I think there is a website called Disband the Committee, which has resources like today's webinar. Hopefully there are other resources that are up online. You can go there and you can examine the representations made to the committee. You can examine in greater detail the questions that are raised at the committee. Hopefully LiveLaw will also have will give you access to the website of the committee itself. Please go and see the committee's resources. Please see what is the call for responses they put out. Please see their questionnaires, and also look at what is the critique that has been made against them. And if you are so convinced, please send emails both to the Home Minister as well as to the committee, asking them even at this stage to suspend this process and to wait until the pandemic has abated and to undertake law reform in true earnest.
Thanks, Jawahar. Rebecca, did you want to say something to end? Or?
Thanks. Thank you very much. I just wanted to thank LiveLaw and to you, Mayur, for organizing this. Thank you very much.
Thank you very much. Thank you, everyone.